Hi, I'm Dan Covington, and you can always find me at estateplankansas.com. What is probate, and why do people always say you should avoid it? Well, here's a typical probate process in Kansas. There are variations, but when a loved one dies with a will in Kansas, you locate the will, hopefully in a safe deposit box or a safe somewhere, because the original is going to be filed with the court. You file that will, and you petition for probate of the will and seek appointment of an executor. Then you publish that the proceedings are going on. You publish also at the same time notice to creditors that they can exhibit claims, file claims against the estate. Most creditors, creditors that you don't know identification and address for are going to have 4 months from the time you first publish to file a claim. Anyone who gets direct notice by mail, they only have 30 days. Then the court, probably through a hearing in the short term, is going to appoint an executor, someone to administer and oversee the estate and deal with the court. That executor, within 30 days of appointment, is to file an inventory of the estate, kind of a list of the, at least the major assets of the estate. After that inventory, if there's not a lot else to do, there could be a waiting game for claims and some time to administer the estate, sometimes to answer questions of family, deal with maybe tricky assets, tenancies, something that needs liquidated, cattle that need cared for. Then sometime as that wraps up and you've started dealing with all the creditor claims, you're going to publish again that the estate's going to close. You're going to close and distribute the estate with court oversight. So this is when you're finally going to get to do what the will asked be done with the decedent's assets, hand those things out. And this was generally at least about a 6-month process or more. It can go well over that, but 6 months is, for a fairly routine probate proceeding, 6 months is somewhat average short time, I would say. Let's contrast that with a trust. So with a trust, on the death of a loved one, a new trustee follows the instructions in the trust. They make distributions if the trust so provides. So they start handing out, paying out, writing checks, conveying things, or in some cases it may just be that the trust is available, those assets, to care for the surviving spouse during his or her life. Again, this is a simple process. The loved one dies, the trustee takes over, starts making those distributions, or using the funds to care for the surviving spouse. There's no publicity, no court oversight, no delay. You can see the obvious advantage of a trust over a will. Trust this information may be of use to you. I'm Dan Covington. You can find me at estateplankansas.com.